A new Utah law was aimed at protecting our right to defend ourselves.
Yeah, but as KSL investigator Daniela Rivera found out, that self-defense law is coming under fire from both prosecutors and victims of crime for its unintended consequences.
Oh, he just would light up a room when he walked in. I know you hear that a lot, but that really was our Corey.
Memories and photos are what's left of a life cut short.
He was the best friend anybody could ever have.
Kaylin Stafford says it was an act of kindness for someone her son considered a friend that led to Corey Haney's death in March of 2019.
He was needing a place. He had nowhere else to go, and Corey said, come live with me. And next thing we knew, I get a horrible phone call from the police department.
Once a roommate, now a suspect. Jesse Bruce is charged with murder. He told police he killed Corey in self-defense. Now, Kaylin worries the charge could be dismissed without a jury ever hearing the case.
So how can that be?
It's possible under House Bill 227, a new self-defense law that went into effect in May.
In our system, a preliminary hearing has to establish probable cause to bring charges. At trial, prosecutors have to prove those charges beyond a reasonable doubt. But a claim of self-defense now triggers a new process, requiring prosecutors to prove with clear and convincing evidence that the accused did not act in self-defense. And they have to do that before the case goes to trial. Prosecutors say it's a high bar for a pretrial hearing, especially when they're still working through the evidence.
If we can't meet that, then the case is thrown out. It's just jettisoned.
Salt Lake County District Attorney Sim Gill says the law is already impacting cases.
Well, this is just a sampling of the collateral consequences of House Bill 227 getting passed.
Those court papers represent people charged with serious violent crimes who are now demanding justification hearings under the new law. Jesse Bruce is one of them. His October trial was postponed once again, and now a justification hearing is scheduled for January. Even if prosecutors are successful, Corey's mom says it's an extra step in a process that's already painfully long.
It's excruciating. It's another brick in our backpack.
This is going to continue to clog our criminal justice system and re-victimize victims.
It's better to let 9 guilty people go free than it is to convict one innocent man.
Mitch Velos is a Utah defense attorney and author. One of his books examines self-defense laws in all 50 states.
It's just a little higher burden of proof.
That's how he learned about a unique portion of Florida's Stand Your Ground law.
And then I thought, let me mention that to the legislature.
So this law was born from your research for the book.
Right.
House Bill 227 brings Florida's justification hearing process to Utah. The intent?
Hesitating even a split second can get you killed.
Velos says people should be able to act in self-defense without worrying about the cost of defending themselves later in a trial.
The risk of dying should be on the criminal or the assailant, not on the defender. And that's why I proposed this law.
Outside of Florida and now Utah, Velos did not find any other state with this specific legal process.
Are we a leader or are we the guinea pig?
No, we're a leader.
We are unfortunately a very terrible guinea pig here.
Gill says the new law comes at a cost.
And we warned of these collateral consequences. Those were ignored.
His office and others did warn lawmakers as the bill went through committee hearings.
They will be requested, we think, with an incredible frequency, taxing the courts in a way that is really untenable.
This is a new section of code that basically copies and pastes from Florida statute.
On the House floor, the bill's sponsor, Representative Carrie Ann Lisenby, encouraged fellow lawmakers to support the legislation.
Currently, individuals who use their firearm in self-defense are subject to prosecution and often a costly jury trial.
Both the House and Senate passed the bill with less than 15 minutes of debate. But since the law went into effect in May, Gill says it's not just impacting cases involving gun owners.
I have one person who's stabbing another person. I have another person beating somebody over the head with a rock. And these are all now becoming evidentiary justification hearings.
The case surrounding Corey's death, too.
This is not even a gun case.
No, it wasn't. He was stabbed. Brutally horrible. It was horrible.
Kaylin says Corey was unarmed and stabbed multiple times.
Anyone under existing law can defend themselves.
Allison Anderman is senior counsel with the Giffords Law Center. Both Anderman and Gill say the right to self-defense is already built into the tradition of the criminal justice system.
So it's not giving us anything new, but it is costing us a lot.
People could always claim self-defense, they say, but now the decision shifts from a jury to one person, a judge.
The Utah legislature has given people a get-out-of-jail-free card for murdering other people.
Did you consider that this law could incentivize frivolous self-defense claims?
If we look at the statute as a whole and we weigh all of the provisions in the statute, I am not concerned with that. In fact,
we sat down with Representative Lisenby to share what we learned and how the law she sponsored is impacting Corey's family.
I do think this is a well-balanced statute, but again...
But this interview ended abruptly.
So, you know, you asked me for 4 questions, and you've gone well beyond and outside the scope of those questions.
Representative, you're still mic'd up. We'd like to continue speaking with you about this bill.
We don't send interview questions, but we did email Lisenby 4 topics we'd like to cover, including how the new law is working. 2 days later, Lisenby agreed to continue the conversation.
I believe it's functioning in the state.
She told us the law was intended to address politically motivated prosecutions, but could not provide examples of that happening in Utah.
There may be cases, I don't know of any, but I do know that they are happening.
But you don't know of any specific ones, you just know they're happening.
I think I just answered that question.
Lisenby said after reaching out to several groups and agencies, she doesn't believe there are serious issues with her bill.
And nobody could back up the assertion that there are broad concerns out there.
The KSL investigators reached out to the top prosecutor in every county in Utah. Most told us because the law is so new, it hasn't impacted them yet. In 6 counties with scheduled justification hearings, none of the prosecutors support the law. 1 is undecided, 2 neutral, 3 are against it.
Fundamental to our criminal justice system is our jury system.
That includes the prosecutor in Juab County, who had a murder charge thrown out after an August justification hearing. The presiding judge called it the most difficult decision he's ever been asked to make and hoped lawmakers would take notice.
I hope they will evaluate whether this new statute has had the results they intended.
Troy James Paxton claimed he was justified after shooting his friend while breaking up a drunken brawl. A jury could have reached the same decision after evaluating all the evidence, but the family of Michael Cossey, the man killed, will never know.
We all feel the justice system has no doubt failed us.
And for those who will undoubtedly leave today feeling that justice has not been done, I encourage you to seek out your representatives and discuss your concerns.
Lisenby stands by the outcome of that case.
And so he shouldn't have to face a jury trial. He should be able to avoid that emotional and legal expense.
She says people who use self-defense in Utah are victims.
What I did, I heard from victims and I acted, and that's the result, HB 227, and I'm grateful that I could represent those victims.
I think it's very difficult for victims.
Laurel Hanks is an attorney who helps a different kind of victim, not the accused, but people who've lost loved ones and want answers.
Honestly, I don't even know what to tell them because there are no words to describe what they've lost.
What would you want legislators to know?
I hope they would get more information about how this impacts real people.
People like Kaylin, a mom facing another holiday season without her child. Her chance for justice now hanging in the balance.
It's my son's life. You know, he's gone. He can't come back. And he needs his story to be heard. He needs a jury to make that decision.
Utah is one of only 2 states.
Based on what he's learned from Utah prosecutors and a KSL investigation, Democrat Representative Brian King says Utah's legislature should reconsider House Bill 227, a new self-defense law that went into effect in May.
Look at it. I think we should take another look at it simply because it was not well thought through to begin with when we considered it last year.
The new law shifts the burden of proof for self-defense to prosecutors during a pre-trial justification hearing. If they can't prove that a use of force was not self-defense, the case gets dismissed before it ever goes before a jury, and it's already led to a murder charge being thrown out.
I worry that it increases the likelihood of vigilante thinking.
Republican Representative Carrie Ann Lisenby sponsored the bill, and debate on the House floor lasted less than 15 minutes.
Have the courts been consulted on this?
Yes, they have, and they participated in the drafting of this language as well as the companion resolution HJR 7.
We also asked Lisenby about the court's involvement.
We worked with the courts on this bill to make sure that it was the right process.
When the KSL investigators followed up, a legislative liaison for the courts said it's true that the courts helped draft procedures to accompany the bill and made language suggestions. But the substantive policy issues in House Bill 227 were not the subject of input from the courts, and the courts took no position on the legislation. To make the case for why the bill was needed, Lisenby referenced an incident that lines up with a 2019 shooting in Provo. A man happened upon an apparent domestic violence situation and ended up shooting and killing the alleged aggressor.
This man acted in the defense of another person and was involved in a drawn-out legal process for over a year.
But that man was never charged, a decision prosecutors announced 6 months after the shooting.
And he had to, all that whole time, retain an attorney and go through the expense of an attorney before the case was dismissed.
But this law would not have impacted that case. He was never charged.
At the time, that case had not reached a conclusion.
That was in 2019, was the decision. This conversation was in 2021.
I don't believe that it had.
That decision was announced in December 2019, more than a year before this discussion on the House floor.
It concerns me because there may be some unintended consequences that are significant.
King voted no on the bill, but a majority of his colleagues supported it, and House Bill 227 is now the law.
Our credibility as legislators is on the line, and it should be on the line.
King says it's important that the debate surrounding proposed legislation is accurate.
In a 45-day session, when you're talking about literally hundreds of bills that come before us, you have to rely on your colleagues.
This is video made public for the first time today. A dash camera inside John Michael Clara's SUV captured the moment he says a truck with a snowplow started ramming into him on the evening of November 23rd, 2019. The final impact spun Clara's SUV around, leaving the vehicle and the camera facing south in the northbound lane of 900 West. You can't see what happens next, but you can hear the gunfire. 7 shots that led to 7 felony charges.
I don't remember if he backed up.
But Clara claims he was acting in self-defense. Today he testified the truck was about 50 feet away from him when he saw brake lights and worried it was turning around.
I was just aiming, to let him know, if you come back this way, you're going to get shot.
But prosecutors believe Clara's actions endangered others. One of those bullets flew through the cab of a different truck stopped nearby, where a man, his wife, and his 12-year-old daughter were waiting for a train to pass.
I observed that she had glass in her hair.
Luckily, no one was hurt. The truck with the snowplow was later found abandoned nearby, crashed into a chain-link fence.
We weren't able to determine who was driving that vehicle.
Raise your right hand, please.
Monday's justification hearing represents a brand new court process in Utah under House Bill 227. The new law creates a chance for people who claim self-defense to have their charges dismissed without going to trial. Prosecutors have to prove in a pretrial hearing that the accused was not acting in self-defense or the defense of others.
They don't have to spend the enormous amount of money to defend themselves at trial.
Mitch Vilos is one of 2 attorneys listed as representing Clara. He told KSL investigators he found this process in Florida's Stand Your Ground law and pitched the idea to lawmakers. Vilos and Clara both testified in support of the bill during legislative committee hearings.
This law, if it were passed, it would help people in my situation.
It's now up to the judge in Clara's case to decide whether prosecutors have presented enough evidence to prove that Clara was not justified on this night 2 years ago when he opened fire.
Supporters of this law, including the bill's sponsor, Representative Carrie Ann Lisenby, have said it will save people who've acted in self-defense from a lengthy and expensive legal process. But in Clara's case, the law is certainly not saving any time. His trial was canceled last June after he asked for this justification hearing. And now we've learned the judge isn't likely to rule on the issue of self-defense before February. Back to you.